All right. So this is the latest that we are getting for more on this as well. We are now being joined by a Satyamale lawyer as well. Now, of course, this is the big verdict that has come out. We are now getting reactions from both sides of the political spectrum. There we just heard Shehzad Poonawala as well. What's your assessment of this?
First of all, it is a very important verdict in context to the UAPA law. Delhi riots, per se, led to killing of 50 civilians, and it had some kind of a conspiracy behind it, which the prosecution has placed on table. And Section 43 D5 clearly states that at this particular juncture, if UAPA Act is invoked, the Supreme Court, or for that matter, any trial court or high court, has to rely on the material placed by the prosecution, and it cannot just merely proceed on the provisions of CRPC at the time of granting bail, because these matters of UAPA, they interject with subjects such as national integrity, safety, security, and sovereignty of our nation. And in this particular context, the Supreme Court has taken a very clear view in interpreting the Section 43D5 as well as Section 15 of the UAPA Act. And therefore, it is a very welcome judgment. And yes, we can definitely say that there is some amount of ray of hope for these two people. That is Umar Khalid and Sharjeel Imam. That Supreme Court has mentioned that 1 year period is now directed to be, used by the prosecution for examining the witnesses, and these people can renew their bail pleas at the trial court at the end of 1 year, or completion
Hmm.
of the examination of witnesses. But that doesn't lead to some kind of a relief or translate to some kind of a relief. Expedited trial is also informed by the Supreme Court. But having said this, it is a strong message for people who want to play with the national safety, security, integrity of the country and want to get away with it. Well, I am also seeing that there are some kind of narratives that are being spread that they are being held because of certain kind of religion they belong to, and so forth. Absolutely not. Indian judiciary is very impartial, transparent. These kind of incidents have been observed when, for example, in Malegaon bomb blast case and so on and so forth, the accused have spent more than 8 years in jail. At that point of time, also, the judiciary has not, looked upon what caste, religion these kind of accused have belonged, and the judiciary has played a very balanced and what we can say a judicious role in granting or rejecting bails.
Right, sir, absolutely. And in fact, a couple of things that you've mentioned there as well that we also need to point out here and that we have been discussing at length. Now, the Supreme Court has stated that it has consciously avoided adopting a collective or unified approach when it comes to all the accused, in light of which we've seen the 5 others who've been accused, they have been granted bail in this case. They've also found these two, Sharjeel Imam and Umar Khalid, to be central to this entire conspiracy. And as you mentioned, the expedited trial, which is now that is something that remains to be seen as well. So do you think the onus is now on the trial court?
Yes, the onus is on the trial court. At the same time, it is extremely important that the Supreme Court has stated it very clearly that these two people are now apparently on the face of it, ex face, appear that they have some kind of role that is directive in context to conspiracy, in context to implementation, and in context to the larger conspiracy that was involved in spreading violence, which was directly targeting to the national integrity, sovereignty, and safety of the country. So therefore, it is very important that these two are placed on a different footing. They be tried, and their evidences against them and everything is to be evaluated minutely, and therefore their bail applications are also treated in a different manner. No parity is granted to them as in context to others. Now, having said this, expedited trial is not something which is, definitely going to be construed as okay, they are going to be released on bail, or they are going to be acquitted or convicted. It is definitely meaning that justice should, be expedited. That's the limited scope of that particular interpretation, nothing more.
All right. Do stay on with us, Advocate Malaya. Of course, we also have with us Anshul Singh, who has been bringing us all the developments on this front. Now, Anshul, let me just come to you. Of course, as we were talking about this earlier, there are reactions which are pouring in. Now, we just heard Shehzad Poonawala as well. What can you tell us, Anshul?
Well, definitely, it is expected. The reactions that are coming up are definitely on the expected lines, and over the next few minutes, we can expect the official reaction to come in from the left back parties and student unions as well. Because remember, these were the unions that were at the forefront of this entire riot and protest that were happening post the CA bills were passed by the parliament. So yes, their official reaction is still awaited. But yes, the Congress party and by the way of Udit Raj have gone ahead and said that this entire judgment is actually unfortunate, and in fact the manner in which Umar Khalid and Sharjeel Imam have not been granted bail is actually unfortunate, whereas the other section, that is from the side of the BJP, this entire judgment is being seen as a stamp on the investigation and the allegations that were put forth against Umar Khalid and Sharjeel Imam as to how they were actually planning to go ahead and carry out some sort of a security situation, disrupt the security situation out here in the national capital, specifically at the time when Donald Trump had visited India back in 2020. So definitely there are the judgment that has come in from the Supreme Court has definitely given a lot of boost to the allegations that were put forth against Umar Khalid and Sharjeel Imam. And over the next few minutes, as I mentioned, that we can expect an official reaction that could come in from the side of the left-back student unions as well.
All right, Anshul. Now, let me just come back to you, Advocate Malay, for more on this. Of course, now with this verdict out, it really just sets the tone for the UAPA Act as well, and any sort of cases regarding this. What's your assessment of that, sir?
Interpretation of UAPA Act. One key takeaway today is Section 15. Supreme Court has clearly mentioned that terrorist acts need not be limited only to murders, killing, bloodshed, and so on and so forth. It can also involve conspiracy to have some kind of negative impact on the peace, harmony, as well as economic activities, and so on and so forth. So this kind of interpretation has got ramification across various cases, including the present one, and this is going to be the key takeaway at the time of trial also, and we have to see how this is particularly taken ahead by the prosecution in the finality of this particular case.
All right. Also joining me right now on the broadcast, Advocate Swapnil Kothari. Thank you so much for joining us, sir. Of course, the big verdict is out. There is no relief for Umar Khalid and Sharjeel Imam. What's your assessment, sir?
Well, this is very much an anticipated verdict for the simple reason that the UAP is a draconian legislation, and the court ensures that the interpretation of the act and of particularly Section 15 is absolutely purposive interpretation, meaning it meets the purpose. And if there are any activities that fall within the thresholds or the purview of that particular section, and of course the BNS sections of conspiracy, etc., then an unlawful assembly, then what happens is that the court will ensure that the bail is not granted. The bail is the rule and jail is the exception, but UAP is a draconian legislation, much like the Makoka in Maharashtra. So, for the simple reason that these activities which threaten the sovereignty, unity, and integrity of the country need to be stemmed, the rot needs to be stemmed and nipped in the bud. And that is what the court has ensured. And that's why that lengthy order, normally the court will finish that order, reading the order in about 5 minutes or so, reading some 2-3 paragraphs and giving the final, order, the ruling. But it has gone into explanations. It has ensured that Article 21 is also covered. But at the same time, that there is an exception to that, something like the UAP, which is a draconian legislation. And that is why the court is telling the viewers and the country at large that, look, when it comes to personal liberty, it is sacrosanct, but not at the cost of the several people who've been murdered or who have been, deprived or bereaved of their homes, etc. So that is what the court is saying. And for the 5 people who have got the bail, the court assessed each of them individually, which it should. For example, if I were to hide a potential murderer in my house and say, okay, after an hour you can go and commit that murder, I'm considered as an accessory before the fact, so I'm less of a criminal as opposed to the person who actually goes after an hour and kills that person. So the court has distinguished depending upon the culpability or the mens rea, right, what we call as the criminal intention. And that's how it has decided that, look, it's a pre-trial stage. These two do not deserve a bail under any circumstances. And possibly when the trial goes, it happens, and especially it's directed as speedy trial, possibly they could meet the gallows or a full life imprisonment. And as far as these 5 are concerned, they need to be out on bail for the moment. And as long as they don't, there'll be certain conditions imposed. They'll have to come to the police station. Their passports would have been impounded, etc. And then, when the trial takes place, they're back in the dock.
All right, for more on this, we also have with us Ananya Bhatnagar, who's joining us right now. Ananya, thank you so much for staying on with us. Of course, you've been tracking all of the developments very closely. You also spoke to Additional Solicitor General Advocate S.V. Raju as well. Now, Ananya, what have been your key findings here?
Well, this is a case that it stemmed in from almost 2,500 pages of charge sheet in the first place, and subsequently 4 more supplementary charge sheets were filed against various accused persons. So it's a humongous evidence that has been presented by the Delhi police, and that affidavit, the last nail in the coffin was that affidavit that was filed by the Delhi police before the topmost of the country, wherein they had categorically stated that this was no protest, it was nothing but a regime change operation that was operating under the garb of peaceful protests that were, against the Citizenship Amendment Act. And this was a plan to actually hijack the national capital somehow by creating a chakka jam, by obstructing the essential services. And the Supreme Court, when it has delivered its verdict, clearly singling out Umar Khalid and Sharjeel Imam as far as things are concerned, has very categorically stated that, though there is a constitutional right to life, there is a constitutional right to free speech, but they all come with reasonable restrictions under Article 19(1)(2), and those restrictions are something that needs to be viewed very seriously at times, because if at all the public order is being hindered with, if at all there is a unrest being caused, then there is no place for a bail or no place for a liberty that needs to be granted, is what the essence of this judgment that has come out of the topmost of the country is concerned. Though a balancing act has been done by the Supreme Court by singling out Umar Khalid and Sharjeel Imam, but very clearly Gulficha Fatima, Shadab Ahmad, and various other people have been granted bail. But the Supreme Court is very, very clear that the grant of bail to these accused persons also does not mean at all that there is a dilution of any charge against them. It is just because they had been in prolonged incarceration, and their role is not a central role but a role of a facilitator, and hence this bail has been granted by the topmost court of the country to these people and denied to Umar Khalid and Sharjeel Imam.
Right. Advocate Kothari, let me just come back to you. Let's just talk a little bit about the judicial reasoning here as well. There's, of course, the culpability hierarchy that we're seeing, that there's the prima facie evidence, there's trial delay, and, of course, the interpretation of the UAP, as you were mentioning earlier as well. One of the major points here, of course, that perhaps require further examination for benefit of our viewers would be, of course, the court observing that they do not surpass the bar of section 43D. What could you tell us about that, sir?
Well, the point is that, delay and any other tangential arguments are not sufficient because certain aspects of delay in this particular case were at the instance of the defendant itself, or rather the accused itself. So the point is that the court is trying to say that you ask for adjournments because it's basically, let me tell you, the judiciary at times is definitely to blame when it comes to, the judge is not sitting or trying to give adjournments very easily. But it's us lawyers who are more significantly to blame, for the simple reason that we ask for delays and adjournments simply because we apprehend, if I do this case today with all the media hype surrounding, maybe I'll lose. And Sharjeel Imam and Umar Khalid will not have any chance in the court whatsoever. So let me try to drag this on, let them be in jail, but at the same time, they have a solid chance of bail maybe 1 year down the line. So the delay is something which the court is not looking at. The court has said that apart, we are going to go strictly by the provisions and the interpretation of Section 15 UAP, BNS, and the involvement. And as Ananya Bhatnagar pointed out, that the role of these people was not simply to just, create a protest, which is very much allowed in this country as per freedom of assembly, which is a fundamental right under Article 19. But when it comes to violating public order, which it did because there were riots, obviously the reasonable restrictions are there. And that is the reason why we are not going to let these 2 people off. The remaining 5 are concerned. Their culpability is a little less down the order, but there is definitely a larger intention. Let me point out for the benefit of your viewers that it does not stop at these 7 or 8 individuals. There is a conspiracy, larger one. You don't just go out and create these riots or have petrol bombs and things like that unless you're financed in a very, very big way of a larger conspiracy to disembowel the nation, and you have hired the topmost advocates in the country. Where do you get the money from?
All right. Well, Advocate Malay and Advocate Kothari, thank you so much for joining me on the broadcast with your perspective on this.